Oh, a new witness? No way. Real? Show me.
For Pirate 6 specifically, you assume that he would
Who
have
is he?
paid $22.5 million on Pirate 6, right?
Oh, I see it. Hold up.
Correct.
And you took Jack Wiggum's word for it in making that assumption, correct?
I based it on his testimony, yes.
Now, you never saw a contract that Mr. Depp had for Pirate 6, correct?
Correct.
Oh, I want to see that actually. Guys, I'm gonna watch it for a little bit.
So far as I know, I've
Guys,
not seen
he's
one.
a
You didn't take into consideration Jack Wiggum's testimony that Disney was non-committal about
economic
Mr. Depp
damages
Pirate
examiner.
6 even before the op-ed, correct?
Correct.
And you didn't take into consideration the press articles that came out prior to the op-ed that suggested that
Chat.
Disney had made a decision.
So he's gonna figure out if they lost a lot of money and whatnot,
Correct.
and how much, right?
And you have no idea whether Pirate 6 will ever be made.
I'll watch it for a little bit.
I wouldn't know that.
And you have no idea if Disney has decided one way or the other whether Mr. Depp would be in it or whether they'd offer him a role in it if it is ever made, correct?
Well, my understanding is that they made a public statement that he would not.
Okay. And you have, if Disney decided that he wouldn't be in it, you have no idea when they decided that, correct?
I know that there was a public announcement subsequent to the publication of the op-ed.
What public announcement are you talking about?
I believe there was an interview of Mr. Bailey that was published several days after.
Okay, well, that interview with Mr. Bailey didn't say that he wasn't going to be in it. In fact, have you looked at the article that the jury saw the headline for yesterday, dated November 5th, 2020, about Mr. Depp potentially not being in Pirate 6? Have you looked at that article? I assume not.
No.
Okay. And you didn't take into account Mr. Depp's statement that he wouldn't do Pirate 6 for $300 million and $1 million out pockets, correct?
That sounded like hyperbole to me. I didn't take that very seriously. It
Okay.
sounded like somebody who was a bit hurt or in pain as a result of the loss of the role.
So if Mr. Depp...
How did I go to live? How did I go to live then? Thank you.
Because of the op-ed,
Fuck.
but he lost it for other reasons, then your damages opinion relating to Pirate 6 would drop to $0, correct?
I believe that's correct. If it's not lost for that reason, if it's lost for some other independent reason,
Guys, it
then
was
I think
behind. It was
that would
behind.
be
That's why.
considered.
Okay, thank you. Now let's shift gears and talk about the non-franchise earnings for a moment. You claim this number is about $21 million, right? Roughly.
20.
We'll pull it up. Well, actually, we'll look at the chart here. $20 million, about $20 million after agent fees.
Correct.
Okay. And to reach that number, you looked at what his historical earnings records showed, right?
Correct.
Guys, this looks pretty good. So I mean, watch out.
And you got that information from Ed White's office?
Yes.
And you assumed that the information you got from Ed White's office was accurate, right?
I did, yes.
We'll see
Can
though.
you please pull up the chart that's in his expert report? Your Honor, this is, or Mr. Spindler, I'd like you to take a look at this and confirm for the court that this is the chart that's in your expert report.
Chat. Can we get the other guys? Can we get the other one?
It appears to be, yes.
The other broadcast that
Your
has
Honor, I ask for permission to publish this just as a
the
demonstration.
published evidence
No
on it.
objection.
All right.
Everybody have it? Can you pull it up, please? Michelle, blow that shit up. Michelle, in chat, blow that shit up. There it is. Sorry, I got it. Thank you, Michelle.
So, Mr. Spindler, this chart shows Mr. Depp's earnings by year.
Oh, wow.
Based on the information that you received from Ed White, correct?
Correct.
From 2009 to 2020.
Yes.
And it shows that from about 2009 to 2019, and I didn't add these up visually, but from your report, you say that Mr. Depp made about $459 million. Correct?
Correct.
Now, the two highest earning years in this time period were 2010 and 2011, right?
Yes.
You see that? You made about $70 million in 2010.
I do, yes.
And then the third highest year was 2014, right?
Yes.
Stayed under 60 million.
No.
And you'd agree that from the period 2010 to 2020, his annual income on average was decreasing.
Yes, but you have to take a look at the components of this.
Right.
And
And in
as we-
2000, I was just wanted to get your agreement that from 2010 to 2020, his annual income was decreasing. Now, in 2020, he earned
they can
more
anything.
than he did in 2016, correct?
I want to watch this.
On an overall basis, yes.
And in 2020, he earned more than he did in 2018, correct?
Yes, just
After the
based on
op-ed.
earnings.
And in 2018 and 2019, he earned an almost identical amount, correct?
Yes,
And
just based on
2019 and
earnings.
2020 were both after the publication date of the op-ed, correct?
Yes.
Okay, now I want to talk about some of these non-franchise earnings because when I looked at your chart that was displayed to the jury, I didn't see anything specific listed. So can you just confirm for me that you can't name a single lost business opportunity other than Pirate 6 that Mr. Depp lost as a result of the op-ed?
That's correct. That's not
And
the
you can't
nature of this
identify a
calculation.
single television, if you could just
Damn,
answer
he's
my
doing
question
pretty
yes
good.
or no as best you can, please. You can't identify a single television project that Mr. Depp allegedly lost out on as a result of the op-ed, correct?
Correct. That's not the
And
nature
you
of this.
can't identify a single
Guys,
advertising
even if it's just
or marketing opportunity
Pirate
that
6
Mr. Depp lost
with
out on as a result
with
of the
all
op-ed,
the licensing
Right,
and the
these are the
fucking
calls
So it's
not
fair
all
to
the
say that
deals,
for
the
si- for-
merchandise,
for-
and the
for
royalties,
lost
it's a lot of money.
opportunities that you can't name, you're assuming
Doesn't
as
matter.
with Pirate 6 that those opportunities were lost because of the op-ed, correct?
Correct.
Now, you mentioned something interesting in your direct and in your report. You
Fantastic
say
Beasts,
you
yeah.
used 2017 as the base year to calculate what you claim Mr. Depp's should have earned in 2019 and 20, correct?
Correct.
And let's take a look at this because 2017 he made that much, correct? About 45 million or so.
Yes.
But in 2016 he made just a shade over 20, correct?
Correct.
2018 he made a shade under 20, right?
He's drawing a dick, but sure.
Yes.
Same with 2019, right?
Correct.
And then 2020, he actually made more than he had in the prior 2 years or in 2016 and made about, what, 22, 23 million or so? Is that right?
Right. But as I indicated,
Only.
this is
So,
just based
the
on
mic,
earnings.
come on, man.
Right. So you said, there were a couple interesting
Man,
things
just
you said.
fucking, dude,
You said that
please.
the most recent, that 2017, I want to explore why you relied on that. Now, first of all, you said that you relied on Jack Wiggum's testimony that 2017 was a reasonable year to use, correct?
Correct.
Despite the fact that 2017, he made more than twice as much as he's made in any year over the last 5 years, correct?
Yes,
And you
but when
say
you
that
take a
this-
look
you said that
at
the most
their,
recent-
if I can
No.
finish
You
this
answer
thought.
my question. No. Well, I want to get to your thoughts because you said that one of the reasons you used 2017 was because it was you said, I wrote it down, the most recent clean year, right?
Correct.
And then I think you explained, you said because the op-ed was written in 2018, right?
Correct.
But the op-ed wasn't written until December 18th, 2018, correct?
Yes.
So the first, if 2017 was clean, then the first 352 days of 2018 were also clean, weren't they, sir?
If I may explain, Mr. Wiggum testified that for the first half of 2018, Mr. Depp chose to take some vacation time. Also, he chose to go touring in the summer with his band, and then he did a film towards the end of 2018. With the publication of the op-ed in December of 2018, that would have impacted the prospects for that film that was done in 2018. So he chose to do just the one film in 2018. And then the impact of the op-ed on that film would have meant that it was not a clean period. You could not have looked
So
at that
generous
film to
democracy
get a
to allow
good
the
sense of
courtroom
what
to
his
borrow
earnings
his
should
mic for
have
the
been,
case.
because he didn't have the chance to earn box office bonuses or
Okay,
profit
well-
participations.
well,
And
let's-
so that's
That
why
makes
2017
sense.
is a
Let me
much,
do this a little
much
bit.
better year to use than 2018.
Well,
And
let's
also when you
break
take
that.
a
Let's
look
break
at the
that
bar
down.
for-
I think let's break that down a little bit. You said that 2017 was a much cleaner year, but isn't it also true that there were other reasons why 2018 wasn't clean? For example, the April 2018 article by Dan Wooten calling Mr. Depp a wife beater, correct?
That did occur in that year, yes.
The June 2018 lawsuit that Mr. Depp filed in the UK against the son
Guys,
for calling him a wife beater.
The idea that he's going with, I think is pretty smart.
Yes.
And how about the October articles reporting that Disney had decided to move on from Mr. Depp and not cast him in Pirates 6, correct?
I'm sorry, what effect would that have had?
Well, it came before the op-ed, so it's
Think
another
about
reason
it,
why 2018 isn't a clean year in your mind, correct? An article
No,
2
those
months
aren't the
before
reasons.
Other
op-ed,
articles that he
those
could have
months
sued
before
them
the op-ed
for,
saying that-
other
that
people
Disney had decided
wrote
not
pieces
to
that were
cast
as
Mr. Depp.
damaging, if
That would
not-
also keep 2018 from being what you would call a clean year, correct?
I guess, right?
I've described the reasons why I believe 2018 was not a clean year.
Okay. Now, you're aware, as we talked about, that Amber's op-ed wasn't published till December 18th, 2018, correct?
Correct.
So Mr. Depp could not have lost out on any opportunities as a result of the op-ed prior to December 18th, 2018, correct?
Correct.
And he couldn't have lost out on any opportunities in 2017 as a result of the op-ed. Fair?
Fair.
Correct.
And he couldn't have lost out on any opportunities
gonna project
in
the 16.
2016 as a result of the op-ed, correct?
Correct.
And so in calculating your damages, you didn't use 2016, you didn't use 2018, but you chose to use 2017, correct?
Yes,
And
for very
Mr.
good
Depp
reasons.
still made more in 2020 than he did in both 2016 and 2018 before the op-ed was published, correct?
Correct, and that's
Nothing
just
further.
based
Thank
on
you, sir.
earnings.
All right, redirect.
Yeah, thanks, Ron. You explained 2018. Why didn't you use 2016?
Well, first of all, 2017 was a more recent year. 2017 was a year in which Mr. Wiggum indicated that that was a typical year for Mr. Depp. He had a studio film, he had a independent film, he had an endorsement deal. 2016 is further back in time. As I understand it, his earnings capacity for that year would have been just about the same or even higher than 2017, because there was an endorsement deal that Mr. Depp passed on that would have been worth a lot of money, according to Ms. Jacobs. So 2017 made the most sense.
Why did you ultimately use the method that you did to determine the lost earnings?
What?
Because it just makes sense.
What
It's the correct approach to take. You're taking a look at what Mr. Depp would have been expected to earn in a typical year, and then you're comparing that to the period of time where you're analyzing following the op-ed from December of 2018 through October of 2020. So you're taking a look at what you would have expected him to earn. It's very simple compared to what he actually did earn.
No further questions, Your Honor.
All right, thank you. Is this witness subject to recall? All right. Sir, since you're subject to recall, do not discuss your testimony with anybody, but since you are giving expert testimony, you're free to stay into the courtroom, okay, sir? Thank you. You have a good day.
Thank you very much.
All right,
Thank you, everyone.
watch your step there. All right.
Oh, thanks, Your Honor.
Plaintiff.
Nah, he kind of went hard.
All right, plaintiff rests. All right. Ladies and gentlemen, we're going to go ahead and take our morning recess. It may be a little longer because I have a few issues to take up with the attorneys, but then we'll proceed after that, okay? So please do not talk about the case and do not do any outside research, okay? Thank you.
Recess then. Guys, what happens after? Another witness. Yeah, I mean, what can you do when you get an expert in? You're gonna fucking go against the methodology.
Why don't we go ahead and take our recess
Oh,
until 11:45.
oh my God!
And come back and entertain the emotions at that time, okay? All right, thanks.
Now I'm sitting down, dumb fuck. The judge is not gonna fucking scold me, man. She's not even looking, man. She's like a Normandy. Guys, how long is the recess for? Guys, what is that, man?
I don't remember.
And you don't remember seeing anything, right? But do you remember?
If
even
she's
looking?
45, I am 45.
I was gonna say that.
I remember. I'm really sorry, but I remember. I gotta tell the whole story how they got there. Before they went and get the keys, they come down. They say, somebody tried to get into my unit. There's scratches on my door. And like, I'm really sorry, but who will think is gonna get into your unit because it saw some scratches on the door, like what, 4 inches above the door? Because the dog was scratching the door, was trying to get in, and they thought about someone trying to break into the unit. I said, in my head, I was like, you think someone's trying to get into your unit? There's scratches like 4 inches above the floor on your door. That was the dog trying to get into the unit. And they were
Most
so
famous
afraid.
person in the
Oh,
world
somebody's trying
watches
to get
you,
into my unit.
so
Like,
you
oh,
are
come on,
famous.
really? And I actually went. They asked me to go inside the unit just to check room by room to make sure no one was there. So I did that. That's correct. That we don't have cameras in the videos. Sorry, we don't have cameras at the hallway. We don't have cameras on the hallway.
I'm going to show you what has been marked as Romero Exhibit Number 1. It's a deposition that was taken of you on July, back at that time, 2 months after the incident.
Yes, I remember, because like I said, I was.
He had to blow in the breathalyzer to start the car?
But I'm not looking to find something like oh, your makeup is wrong, you haven't have changed your eyebrows, or your eyelashes are not even, or I'm not looking for anything. I'm just looking at their eyes, and I'm not looking for anything else. But if I see something, I will probably will remember. May 24th.
Yes.
Yep, that's Tuesday.
But in fact, you don't recall seeing Amber Heard
Most
on May
reputable
24th,
Amber Heard
correct?
witness.
I don't remember. I don't even remember what I got for breakfast.
Okay. Well, let's pull up Exhibit Number 1. Let's stay on page 17. That's a good place. And is that
Jesus, dude. Best defense witness. We saw the vape one earlier. That's actually funny. Holy shit, dude. That's actually funny. Okay. That was funny. I enjoyed that. Okay, who's going on stand it? Yo, put the thing back,
The
motherfucker.
first two at this point. And because it seems like plaintiff is proceeding under a theory of defamation by
Analysis.
implication, under the Pendleton case, 290 Virginia 162, plaintiff bears the burden of proving that the statements at issue were designed and intended by Ms. Heard to imply a defamatory meaning. Designed and intended to imply a defamatory meaning. So, and to satisfy those first two elements, publication and falsity and defamation or defamatory nature of the statements, Mr. Depp bears the burden of proving that by a preponderance of the evidence. And to satisfy the requisite intent and show that Ms. Heard acted with actual malice, he has a heightened standard of proof that he must prove by clear and convincing evidence that Ms. Heard acted with that malice. So, just want to talk about the two.
How do you prove malice intent beyond a shadow of a doubt? How the fuck can you do that? That's impossible.
Ample Virginia case law talking about how you have to view the op-ed as a whole. You have to view words in context. So these are the statements that read, then 2 years ago, I became a public figure representing domestic abuse. And then the other statement says, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse.
50-50, sorry.
Now, those statements are entirely opinion, except for, according to Mr. Depp, the discussion of domestic abuse. So the statement, I became a public figure representing domestic abuse, and the statement in the second sentence that Mr. Depp was a man accused of abuse. The rest of those are inactionable opinion statements. Now, the evidence adduced thus far, Your Honor, shows that Mr. Depp can't sustain a claim on these for two reasons. First of all, the statements are true on their face. I don't think that there's any dispute about that, and that's been the subject of some testimony in this case. 2 years before she wrote the op-ed, Ms. Heard did, in fact, become a public figure representing domestic abuse when she obtained a domestic violence restraining order
Ironic.
against Mr. Depp, and Mr. Depp was indeed accused of abuse. Those are facts that are true. Now, to the extent that Mr. Depp will argue that he's proceeding on a defamation by implication claim, again, the court should grant the motion to strike because the undisputed evidence is that he did, in fact, abuse Amber. Now, there's a dispute in this case. There's ample evidence that he physically abused Amber, but we acknowledge that there's a dispute in this case on that. But what there isn't a dispute in this case is non-physical abuse. Both Mr. Depp and his expert Shannon Curry have testified that abuse may come in many forms. It may be physical, certainly, but it may also be verbal, may be emotional, may be psychological. You'll recall Mr. Depp even kind of setting the baseline for what abuse was when he talked about the non-physical abuse that he allegedly suffered at the hands of his mother. He said it was worse than the beatings, and the example he gave was that his mom used to call him One Eye as an example because he had a lazy eye, I guess, as a child. That was something that Mr. Depp himself said was abuse, his mom calling him One Eye. So we setting aside the evidence of physical abuse in this case, which is already overwhelming, Mr. Depp's claims relating to these two statements should be stricken because of the ample and undisputed evidence in the record of non-physical abuse by Mr. Depp toward Ms. Heard. There's evidence in the record of recordings, messages, including messages written in blood with his finger, blood and paint, vile names, shouting, menacing and threatening statements. There's the video, the kitchen video in Sweetser. There's the audio of him calling Miss Heard
after having his finger cut off.
Numerous vile names. There's the audio of him asking her to cut him, and whether she wanted to be cut. So there's plenty of evidence out of the words or out of the mouth of the plaintiff in this case that constitutes non-physical abuse of Miss Heard. Again, under the standards set forth by his expert and the plaintiff himself. Those are far worse than his mother calling him One Eye when he was a child.
That's child
In addition
abuse.
to that, Your Honor, there's Travis McGivern's testimony from yesterday in which he testified that at a minimum on the night of March 23rd, 2015, both parties were being verbally abusive to each other. Mr. McGivern also testified about Mr. Depp, quote, rearranging her closet, throwing racks of clothing down onto the floor and throwing at least one rack down the stairs. Now, in California, property damage alone can be a basis for getting a temporary restraining order under California law. So further evidence of non-physical abuse or non-physical toward Ms. Heard. You saw the cupboards in the Sweetser kitchen video. And then Dr. Laurel Anderson, Your Honor, testified that she believed that the parties engaged in mutual abuse and that at least some of the time that was initiated by Mr. Depp. This is all evidence. We haven't gotten to put on our case yet.
She shit on the bed.
To the extent that this case proceeds, and that will start now. But this is all evidence that has come in while plaintiff controls the playing field of what evidence has come in, and he can't overcome that. In this case, Your Honor, if Mr. Depp abused Ms. Heard physically, verbally, emotionally, or psychologically even one time, then she wins on those claims. Then she wins.
Motion to strike?
It's that simple. And the evidence is overwhelming and undisputed in the ways that I've just described that he did.
That is not how that works.
For that reason, Your Honor, those claims should be stricken. And I'll just cite the Union of Needle Trades versus Jones case. This is 268 Virginia 512 that states if the plaintiff does not establish the falsity of the statement by a preponderance of the evidence in his case in chief, he has not met his threshold.
She's not even listening anymore.
And the trial court should strike the evidence and grant summary judgment to the defendant. That's exactly what should happen here. Now I'll move on to the second issue, which is the headline containing the phrase sexual violence. That should be stricken for a couple reasons. First, Your Honor, the evidence has established that Ms. Heard didn't write the headline. Mr. Doherty from the ACLU, that's the only evidence that's come in this case thus far.
Is it going to get striked?
Plaintiffs control the evidence.
Well, I understand, but there's also a stipulation that Ms. Heard would not be called in the plaintiff's case because they would then use her testimony for part of their case. In your case, right?
That's correct, Your Honor.
Yeah, I agree. And that goes to a different issue that I'm not arguing. I'm not arguing that the court should strike because they haven't put Ms. Heard on to testify about the headline.
But I assume part of that would be that they would, I guess they intend to get from Ms. Heard is that she she either wrote it or republished it. I
Yeah,
don't
what
know.
happened the next day is Ms. Hurd posted it on her Instagram account and said, look what I published yesterday in the Washington Post. So she adopted the title, and her name was on the article which contained the title.
And Mr. Ronborn, the only reason I'm sorry to
No,
interrupt
that's fine.
you,
Of
the
course.
only because I know that was a stipulation, so it's hard for me to say that that's all the evidence for motion to strike if there's a stipulation that they're still going to get more evidence in on that particular issue.
I think, and I'm happy to hand the court the transcript of the April 8th hearing, because one of the things that we're not arguing today is that because they haven't put in evidence of I think it was a tweet, but Mr. Chu says it was Instagram, I don't know, whatever it was, that because there
It
was
was a tweet adopting the op-ed she published
Okay.
the day before in the Washington Post.
Okay.
All right. So what I'm not arguing today is that because they haven't gotten that tweet into evidence or had Ms. Hurd say that she tweeted that we're entitled to summary judgment at this point. I'm not arguing that, but that's all that we discussed on April 8th, and I'm happy to hand the transcript up, Your Honor. And we actually it wasn't a stipulation. It was simply an agreement that they didn't need to call her in their case.
Does that matter
to
in the
make
end
that
for the jury?
And then
motion to
Ms. Rudolph
strike
said
this? Like,
we'd have to agree on the language of any stipulation, and they haven't proposed anything to us and haven't gotten back to us. So I think that's only
can't really
relevant.
erase
We're
memory.
not basing our request for motion to strike here on Ms. Hurd not having testified to sending that tweet.
But you're saying for the motion to strike, the only evidence before the court is that the Washington Post wrote that title.
Correct, and that's very different from what happened the next day. The stipulation didn't go toward who wrote the title.
Oh,
that was never part of
please.
anything. And it's undisputed, and Ms. Hurd will testify that she didn't write the title.
Well, I understand that, but I
It's
think
not
there.
Take a
disputed,
seat,
Your Honor. I apologize
dude.
for interrupting.
Okay. But I think the issue is that whether it was republication.
Well, and I'll get to that next.
But I know, but the problem is, how do I do a motion to strike when that evidence isn't before me yet?
Well, the republication isn't. So the evidence that's before you is that the Washington Post wrote the headline, or that Ms. Hurd didn't, and that's the only evidence, and that's
Right.
not going to change. The tweet, which was the only subject of the discussion of the pretrial conference, where there was no stipulation, it was just an agreement that we're not going to base a motion to strike on them not introducing evidence of the tweet. That was what it was. I'm happy to hand the transcript up if Your Honor would like to see that. But that isn't actionable because under the Lakova versus Halper case, 995 F. 3rd 134, retweeting a link doesn't constitute republication. Now, that case dealt
Well,
with
it does if you
hyperlink.
add something to it, but I just don't know the evidence.
Your Honor, very quickly, it's a judicial admission. They admitted in Ms. Hurd's answer, she admitted to the tweet. So that establishes that she adopted the op-ed in its entirety, and it was discussed. We talked about
Why is he
judicial
laughing?
admissions. One was the op-ed itself. The second, and this is reflected
Your
in the
Honor, if I could
transcript.
finish my argument,
No.
I mean,
I
I would
understand.
appreciate.
I can't wait to oppose this. anyway.
She agrees with him.
Go ahead,
So,
sir.
and again, we can look at the transcript.
You understand my concern.
I do
though.
understand your concern, and I guess what I'm saying is that there's two levels. One is there's no dispute, and there's not going to be a dispute that she did not write the headline. So then you look at is the tweet actionable? And the argument here is that as a matter of law, retweeting something isn't actionable. And so,
Okay.
as under the Lakova case, 995 F. 3rd 134, in that case dealt with hyperlinks and how those aren't actionable. But to be very clear, nothing that was discussed on April 8th, nothing that was discussed at that pretrial conference was in any way relating to any stipulation about who wrote the headline. It was simply that they need not call Ms. Hurd in their case in chief to get her to say that she sent a certain tweet. And that tweet's not in evidence yet, but I assume that they'll try to put it in evidence at some point. But the tweet doesn't need to be in evidence for you to strike this claim on that basis. So even assuming that the headline implied certain conduct by Mr.
I think
Depp,
she might go
again,
for it.
Mr. Depp can't meet his burden of proof on this. Third, Your Honor, he can't prove that Ms. Hurd acted with actual malice. Mr. Depp hasn't introduced evidence sufficient to permit him to meet this. Now, again, this is a heightened burden of proof. He has to show actual malice by clear and convincing evidence. And as
You click the mic, bro! Bro! She muted him! Or he muted himself. What had happened? You fuck! Hello! ¿Qué están?
Ms. Heard's intent on April 8th, which of course we didn't. But the only evidence that has been presented in this case, Your Honor, by Mr. Doherty was that the op-ed wasn't Ms. Heard's idea, that the ACLU asked her to write the op-ed, and indeed that they even wrote the first draft, and then that Ms. Heard vetted the finished article with her lawyers and with lawyers from the ACLU to make sure that it wasn't problematic. That is the only evidence in the record. And on that evidence, there cannot be a conclusion that Ms. Heard acted with the actual malice that's necessary, particularly when you consider the heightened burden of proof. So reviewing the op-ed as a whole, with the court acting in its appropriate function as a gatekeeper of the First Amendment, we ask that the court strike.
It's not closing,
evidence,
it's a motion to strike
and
it.
award summary judgment to Ms. Heard, either in whole or in part. Thank you.
All right, thank you. Yes, sir?
Motion
Good morning,
to
Your Honor. May
strike,
it please the
which
court,
means
thank you for plaintiff Johnny Depp. It's just still morning. Your Honor, if I may approach.
All right. Thank you.
Thank you, Your Honor.
is that what he said? Is that motion to strike it? Is that what he said? Motion to strike from the
I
record.
just handed to Mr. Rottenborn and Your Honor an opposition that we prepared before we had the benefit of seeing Ms. Heard's affirmative motion to strike, that I think we've anticipated the arguments made, such as they are. The court should deny defendant Amber Heard's motion to strike because Mr. Depp has come forward in his case in chief with multiple credible witnesses, documents, and authentic tape recordings of Ms. Heard herself, not only satisfying all of the requisite elements of his claim for defamation, including actual malice, but also going the extra mile of showing that Ms. Heard physically abused him. She's the abuser in this courtroom. Your Honor, going back to the standard, as Your Honor is well aware, in considering a motion to strike, the trial court must view the evidence and all reasonable inferences drawn from the evidence in light most favorable to the plaintiff. Any reasonable doubt as to whether the plaintiff has produced sufficient evidence of the wrong alleged must be resolved in the plaintiff's favor and the motion to strike denied, unquote. And that's the Boeing case I believe Mr. Rottenborn referred to, 243 Virginia 81 at 81, 1992. Quote, the weight and credibility of the testimony of witnesses are solely matters for the jury. The jury may accept that part of the testimony it believes and reject that which it does not. It is also within the exclusive province of the jury to draw any reasonable inferences from the evidence before it, citing Rate versus Minix, 275 Virginia 579 at 585. In deference and respect to the court's time, Mr. Depp incorporates by reference the legal analysis set forth in the court's opinion letter dated March 27, 2020, overruling Ms. Heard's demurrer to the 3 defamatory statements at issue. And that letter opinion is attached as Exhibit 1 to Mr. Depp's opposition. That's where the court fulfilled its proper gatekeeping role that Mr. Rottenborn referred to. As a threshold matter, the elements of a defamation claim are the following: publication of an actionable statement with the requisite intent, citing the Shaker versus Bonfault case 290 Virginia 81 and 91. As to damages, they are presumed here because Ms. Heard's false allegations of domestic abuse, sexual assault, and rape constitute defamation per se, citing the Tronfield case 272 Virginia 709 713, a 2006 case. As the court noted at page 3 of its opinion letter, Typically, an editorial or op-ed column is ordinarily not actionable because it appears in a place devoted to or in a manner usually thought of as representing personal viewpoints. However, Virginia recognizes that, quote, a defamatory charge may be made by inference, implication, or insinuation, citing the Carwell case. And a statement expressing a defamatory meaning may not be apparent on its face, citing Pendleton, with which the court is quite familiar, 290 Virginia at 172. Accordingly, in order to render words defamatory and actionable, it is not necessary that the defamatory charge be in direct terms, but may be made indirectly, and it matters not how artful or disguised the modes in which the meaning is concealed, if it is in fact defamatory. Carwell, 196 Virginia at 7.
That's good.
And based on the authority and reasoning set forth in pages 4 through 8 of the opinion letter, the three statements at issue are actionable under a theory of defamation by implication. Mr. Depp established in his case in chief that Ms. Heard in fact made all three of the defamatory statements at issue. As the court admitted into evidence as Plaintiff's Exhibit 1, the op-ed Ms. Heard published in her own name in the Washington Post on December 18th, 2018. And let's take the three statements and the proof that has been adduced. Statement number 1, Amber Heard, quote, I spoke up against sexual violence and faced our culture's wrath. That has to change. Per page 6 of the opinion letter, the first statement could reasonably convey the alleged defamatory meaning, i.e. that Mr. Depp abused Ms. Heard, to its readers without extending the words beyond their ordinary and common acceptation. See Pendleton, 290 Virginia at 172, also citing the Carwell case. Resolving every fair inference in Mr. Depp's favor, this statement could reasonably imply that the sexual violence Ms. Heard spoke up against was in fact perpetrated by Mr. Depp. Mr. Depp produced several credible witnesses and documents proving that Ms. Heard was implying that he committed sexual violence against her. Mr. Depp himself testified to that, as did his sister, Christy Dombrowski. Mr. Depp's former agent, Christian Carino, testified that, as did his current agent, Jack Wiggum. But perhaps most convincing of all, and most disgusting of all, was the testimony of the ACLU's Terrence Doherty, a lawyer nonetheless. Mr. Doherty testified, among other things, that when when they were pitching the op-ed to the Washington Post, they stated, "Hey, Michael, wondering if we might interest you in a piece by Amber Heard, who, as you may recall, was beaten up during her brief marriage to Johnny Depp, on what the incoming Congress can do to help protect women in similar situations." Mr. Doherty also testified that everybody understood, as Ms. Heard and the ACLU clearly intended, that this statement and the other two statements referred directly to Mr. Depp. Quote, this is an article that was in USA Today and specifically ties Amber's statement in her op-ed piece to Johnny Depp. And when Jessica Weitz, who actually wrote the op-ed that Ms. Heard later adopted, she says, quote, to Mr. Doherty, so much for not mentioning JD, when the USA Today made clear that they, like everybody else who read the op-ed, understood that as Ms. Heard clearly intended, it referred to Mr. Depp, which makes her Instagram post 2 days before the trial began, that she didn't mention Mr. Depp, all the more outrageous. Your Honor, there is Ms. Schulman, also of the ACLU, acknowledged that Ms. Heard's op-ed referred to Mr. Depp. So it's very clear that the ACLU and Ms. Heard intended, that was the whole purpose of this, so that they could get interest in this and it would coincide with the premiere of Aquaman, because otherwise no one would have been interested in anything written by Ms. Heard. Mr. Doherty also testified that Ms. Heard only paid 1.3, actually she didn't even pay all that, out of the $3.5 million that she had pledged to the ACLU, and then they helped her lie about it. And it's one thing, Your Honor, for her to stiff the ACLU, which frankly played a reprehensible role in this case. It's quite another for her to fail to honor her obligation to the Children's Hospital of Los Angeles with sick and dying children.
Jesus.
And that she failed to do as well. And as Your Honor has mentioned, the fact that she put her name on that article means that she is responsible for all of those statements, which she specifically adopted later. And I'll go through the other two statements quickly, Your Honor.
Well, can we stay on this one for one moment, though?
Yes, Your Honor.
Because do you agree that the only evidence before that we've heard in this trial, as far as the title of the op-ed, is that even Mr. Daugherty, I believe, testified to it, that it was something that Washington Post wrote?
Well,
for the one online.
He's not our witness, Your Honor. That's a witness from the ACLU.
Well, I understand, but it's the only evidence I have.
I respectfully
But they
disagree, Your Honor.
acknowledged the intent.
The only real evidence Your Honor has is Plaintiff's Exhibit 1, which is Amber Heard putting her name on the entire article, including the title. That is the only evidence before you. The ACLU was a co-conspirator with Ms. Heard, and whether they say, oh, maybe the Washington Post wrote it.
True.
That's not the end of the story. All she has done is create an issue of fact as to whether she wrote the title or not.
So you're saying just having that exhibit in evidence is enough?
Absolutely, Your Honor. Her name is on the article.
Okay.
What does an average reader expect? So that alone is sufficient to beat a motion to strike. If they want to come back later and say, gee, she didn't write the title, as if that were a defense, I hope they make that argument. I hope they make that argument to the jury, because it's about as credible as her argument that, oh, I wasn't referring to Johnny Depp. She didn't have to. And the testimony of Terrence Doherty was very clear that when they took out the references to Johnny Depp, no one was interested in this article.
He did a nerd voice.
So she said, put it back in, put it back in. Make it more spicy so people would read. Otherwise, she couldn't get it in the Washington Post. It would be back in Teenage Vogue, which is the other publication that was considering publishing it, because no one was interested in what she had to say unless she was defaming Mr. Depp. But if I could go to the second statement, and I'll try to be quick, Your Honor. 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. As for the second statement, defendant called herself a public figure representing domestic abuse, which can be read to imply that she became a representative of domestic abuse because she was abused by Mr. Depp, not just because she spoke out against alleged abuse. This inference can be drawn without extending the language beyond its ordinary common acceptation, citing Carwile, 196, Virginia, at 8. Your Honor, quote, to constitute a publication, it is not necessary that the contents of the writings should be made known to the public generally. It is enough, it is said, if they are made known to a single person, unquote, citing Snyder versus Fatherly, 158, Virginia, 335
which relates
to 350.
with the ACL.
Everybody and his grandmother testified that Ms. Heard was referring to her bogus ex-party TRO
he said
that
what?
she obtained on May 27, 2016. And it was interesting that Mr. Depp's own lawyer said that she wasn't even provided notice. So Ms. Heard made very sure that Mr. Depp wouldn't have notice of the ex-party TRO. And Ms. Heard herself, the evidence shows, knew that Mr. Depp, having just suffered the loss of his mother, was already on the other side of the country, was already in New York at the time of this TRO, and was heading to Europe for several weeks. So she knew she didn't need any protection from him. This was just a scam for her to get the $7 million in the divorce settlement that she said she gave to the ACLU. She swore she gave to the ACLU and the Children's Hospital of Los Angeles, and she pocketed instead.
Yeah, zoom on that motherfucker.
Mr. Depp, Mr. Dombrowski, Mr. Carino, Mr. Wiggum, and the inimitable Mr. Doherty of the ACLU, which lent its once respected name to Ms. Heard's defamation. So while Ms. Heard may have avoided any direct mention of Mr. Depp's name, there is extensive testimony and evidence in the record showing that the implication of her op-ed could not be more clear, i.e., that Mr. Depp abused Ms. Heard during the course of their marriage. Under Virginia law, quote, "It is not necessary that the defamatory charge be in direct terms, but it may be made indirectly. And it matters not how artful or disguised the modes in which the meaning is concealed, if it is in fact defamatory." Citing Carwile. Well, we can argue as to how artful it was, but the implication was very clear, as the court has previously ruled, or not law of the case, but as the court has persuasively written in its opinion letter. Let's move to the falsity of Ms. Heard's ever-evolving and ever-escalating change of IPV and sexual assault. Mr. Depp's sworn denial is all he needs to survive a motion to strike, but there's a lot more than that, Your Honor, and I'll try to be brief.
There's more.
3 police officers, actually 4, but the 3 who testified already, Officers Sines, Haddon, and Gatlin, testified unequivocally that Ms. Heard did not have a mark on her on the evening of May 21, 2016.
Or on the nose either.
And I could go through, I'll just go through very quickly. Officer Haddon, strike that. Officer Melissa Sines on jury trial day 10. Question, did you provide a copy of this pamphlet to Amber Heard? Answer, I did not. I didn't identify her as a victim of domestic abuse. The next day, Officer Melissa Sines. Okay, at this time, did you notice any injuries on Ms. Heard? Officer Sines, I did not. Question, okay, were you looking to see if she had any injuries on her at the time? Officer Sines, yes, I was. Question, and so you were looking to see if Ms. Heard had any injuries and you determined that she did not. Is that accurate? Officer Sines, correct.
They're draining his juice.
Question, okay. And was the lighting good enough in the hallway for you to make that determination? Answer, yes, the hallway was well lit. Officer Gatlin's testimony was the same, and he had the body cam. Officer Haddon's testimony was the same. The testimony of nurses Debbie Lloyd and Aaron Barham, who, like the police officers, did not work for Mr. Depp. In fact, they worked for Dr. Kipper, also belie Ms. Heard's false allegations of abuse. Isaac Baruch and Alejandro Romero both testified that they saw Ms. Heard repeatedly and in the clear light between May 21, 2021, which was the last time Mr. Depp saw her before leaving on the Hollywood Vampires tour. The next time he was to see her was when Ms. Heard begged him to come see her in San Francisco, which is hardly the act of a domestic abuse victim. So we have Isaac Baruch and Mr. Romero saying that they saw Ms. Heard repeatedly in the interval of time between May 21 and May 27th, when she obtained the farce ex parte TRO, and they saw no marks on her face and no swelling. 2 witnesses, Mr. Baruch and Brandon Patterson, saw the video of Ms. Heard and her sister Whitney pantomiming the fake punch after this alleged incident of abuse.
Despicable.
Ms. Heard's former personal assistant, Kate James, and several other witnesses, including Dr. David Kipper, saw no violence by Mr. Depp and no injuries to Ms. Heard. Indeed, witness after witness has come forward to testify that Ms. Heard, far from being a domestic figure representing domestic violence, unquote, is in fact a recidivist perpetrator of domestic violence on Mr. Depp and others. We have the testimony, the harrowing testimony of Mr. Depp himself, who described several witnesses. One, as Your Honor will recall, when he was hiding in the bathroom after escaping one of her attacks, and she claims to have hurt her foot kicking the door. Mr. Depp opens the door to see if she's hurt, and then she kicks the door in on him and punches him. We have the incident of December 15, 2015, when Ms. Heard threw punches at him wildly at the back and side of his head. Mr. Depp testified that he ducked and covered to protect his face. Eventually, he turned around to grab her and stop her arms from flailing. December 15 in the Bahamas, during an argument, Ms. Heard grabbed a can of mineral spirits and threw it at Mr. Depp's face, striking him in the forehead, bridge, and nose area, and the jury saw a photograph of the bridge on the bruise of his nose. We have testimony from Mr. And by the way, Tara Roberts, who is the manager of the island, confirmed that the incident with the mineral spirits. You have Mr. Depp's testimony of what happened on April 22nd, 2016. And we've heard testimony today from Aaron Borum-Filati that Mr. Depp was very responsive, was very sociable, was not in any way inebriated that day when Ms. Heard says he was, and she attacked him that.
Her face. I don't know what she's looking.
She attacked him that night as well, and I'm getting to the end of this, Your Honor. We have Ms. Heard's own admissions. We have her admitting to hitting Mr. Depp, and her only contention was that she wasn't punching him, she was just hitting him. We have testimony from Travis McGivern that on February 23rd, 2015, Ms. Heard threw and hit Mr. Depp with a can of Red Bull and then sucker punched him with a closed
stop throwing shit, man.
fist. Finally, we have the rather stunning testimony of Ben King, quite a credible witness who accompanied Ms. Heard on the flight back from Australia, where Ms. Heard admits to him in a rhetorical question, quote, "Did you ever totally lose it on someone you love?" Which was, we would respectfully submit, an admission of her severing the top or the tip of Mr. Depp's finger. Finally, Your Honor, statement number 3, quote, "I had the rare vantage point of seeing in real time how institutions protect men accused of abuse." Again, quoting very briefly from page 7 of the court's opinion letter, quote, "Drawing every fair inference in plaintiff's favor, the court can fairly conclude that defendant's statement that she saw how institutions protect men accused of abuse could reasonably convey to its recipients that she saw how Mr. Depp was protected by institutions, that he abused her and spoke up against it."
Okay, let's hear it.
Your Honor, again, we have multiple testimony from multiple people, including Jack Wiggum and all the others mentioned, that this was a reference to that. Your Honor, again, the lies that have already been exposed that Ms. Heard has told about the charitable contributions, the incidents in this case, and again, I'll just cite a couple of more, the testimony of Isaac Baruch. When Mr. Baruch saw Ms. Heard on June 3, after she'd gone through with the sham ex-party
The sham?
TRO.
It's not boring, he's rolling.
Mr. Baruch was asked, did she say anything in response? And Mr. Baruch testified, yeah. In response to that, she, meaning Ms. Heard, looks at me and said, "I told Johnny I don't want anything. The lawyers are making me do all of this." And that's what she said. Well, the lawyers are making her do all of that. And apparently she wanted the $7 million for herself. She even lied about the final insult left on the marital bed after her 30th birthday party. And it was quite telling that she admitted to Starling Jenkins, a former United States Marine, that this was a terrible prank gone awry. Well, she lied about that too. In fact, she said Mr. Depp was crazy to even allege that she could have done such a thing. Well, she admitted it to Mr. Jenkins. Per Tronfield, as cited earlier, Mr. Depp does not have to prove damages because this is defamation per se. In fact, these involve some of the most heinous crimes any man or woman can be accused of. However, he has done so. Jack Wiggum tested yesterday that the impact of the op-ed was catastrophic on Mr. Depp's personal and professional life.
I mean,
That it was a $22.5 million loss on Pirate 6 and another $20 million on others. We've had the testimony, so we had Mr. Wiggum testifying as to the 22.5 lost on Pirate 6 and another 20 lost on the other films, the other studio films, the indie films, and the other ways Mr. Depp would have made income.
Fantastic Beasts.
We have Richard Marx's testimony, Douglas Banya's testimony, and the testimony of Michael Spindler just
I feel like
this
he went
morning.
harder here because
Finally,
she was considering
Your Honor, none
striking
of Ms.
the record,
Heard's
right?
affirmative defenses, which would include, her trying to create an issue of fact on the title, can support a motion to strike, as to which she bears the burden of proof of her affirmative defenses. Quote, whether the defendants have met their burden cannot be resolved when considering a motion to strike. See 243 Virginia at 83. And just to respond to Mr. Rottenborn's citation to the Lakova case, which we hadn't seen until he mentioned
Oh,
it
it's about to
today,
correct him. Let's see it.
I would only note, Your Honor, that defendant admits that she tweeted a link to the online version of the op-ed at paragraph 97 of her answer, though again, the admission of Exhibit 1 is more than enough to survive the motion to strike. And the Lakova case at 995 F. 3rd 134 holds that republishing a hyperlink doesn't necessarily start the statute of limitations, not that a hyperlink cannot be defamatory. So with that, Your Honor, we respectfully request that the court deny the motion to strike in full, and let's hear from Ms. Heard. Thank you, Your Honor.
Yes, sir. Thank you. Your motion?
I understand.
Thank you, Your Honor. I can only assume that Mr. Chu wrote that speech for an audience outside the court because it didn't really address my arguments. I'm going to focus on what our specific arguments are for the motion to strike, Your Honor.
That's like
Mr.
saying
Chu
somebody's
spent
sniping it, literally.
Almost 30 minutes of the court's time
That
talking
is
about
weird.
the disputed evidence of physical abuse in this case, which Ms. Heard hasn't even put on her case, and I can tell you she's not the abuser, and if the case moves forward, she and her witnesses will put on even more evidence of the physical abuse she suffered at the hands of Mr. Depp.
That's not going to fly.
But that's not the basis for our motion right now, Your Honor. He talks about how Mr. Depp had a sworn denial, and that should count. We read his testimony. He claims he didn't strike her. But again, that's not the basis for our motion. The basis for our motion is the clear and undisputed evidence of non-physical abuse. By his definitions, by his standards, by the standards of his expert, there is no dispute that Mr. Depp abused Amber. And therefore, if he did it even one time, there's no dispute
This makes no sense at
that
all.
even under their theory of the case, the implication that they want the jury to draw from the article, which again, I'm not arguing for the purposes of today, because under the legal standard, I'm not going to argue that. I'm not going to waste the court's time with that. But even under their standard, the undisputed evidence is that Mr. Depp did commit abuse against Ms. Heard, and therefore that those first two statements were false. That's our argument on that.
It's like saying,
as to the headline, it's funny, Mr. Chu, we played 2 or 3 hours of an ACLU deposition, and now he says, well, that wasn't our witness. It was his witness, Your Honor. He just spent 10 minutes talking about what Mr. Doherty said, and Mr. Doherty testified that the Washington Post wrote the headline. That is the only evidence, Your Honor. I understand he says, well, Exhibit 1 has her name on it. Exhibit 1 has her name on it. But the only evidence in this case about who wrote that headline is Mr. Doherty's testimony. It is undisputed. They could have put
the headline is
they could have called
the
Ms. Heard for that
headline
because that was not part
isn't
of
the main point of defamation. It's the concept of the
It's
article,
only the tweet that we talked
of
about,
which she
Your Honor,
endorsed
and they chose not to do that. Now, Ms. Heard will testify she didn't write that headline, so it wouldn't have helped them. But they've had 3 weeks to put on their case, Your Honor. They've controlled the playing field of evidence. There is no dispute that Ms. Heard did not write that headline. No dispute. Simply saying, well, her name is attached to it, that can't overcome the testimony of the ACLU. They call them a co-conspirator. Of course, Mr. Depp chose not to sue them. But the testimony of Terrence Doherty that she didn't write that headline, that takes care of the sexual violence headline, Your Honor. And I'm not going to take up any more of the court's time addressing portions of Mr. Depp or Mr. Chu's argument that don't go to our motion, unless Your Honor has any specific questions.
It does. It did go to the motion, though. Why he's?
All right. For this motion, I've taken the arguments of counsel, and last night I reviewed all of the evidence that has been submitted in this matter. So as to the second and third alleged defamatory statements, at the motion to strike at this juncture, I view the evidence in the light most favorable to the plaintiff and reasonable inferences from the evidence to the plaintiff. And if there is a scintilla of evidence that a reasonable juror could weigh, then the matter survives a motion to strike. In this matter, there is evidence in the case that a jury could weigh that the statements were made by the defendant, that the statements were about the plaintiff, that the statement was published, that the statement is false, and the defendant made the statement knowing it to be false, or the defendant made it so recklessly as to amount to a willful disregard for the truth. The weight of that evidence is up to the fact finder. So the motion to strike is denied as to statement 2 and 3. The motion to strike as to statement 1, I'm going to take under advisement because if it's not a stipulation, I'm not sure what it is, but there seems to be an agreement that the tweet of Ms. Heard is part of the plaintiff's evidence, which is not in evidence at this point. So I can't rule on that statement whether or not it is just a tweet or if it's some sort of republication or something.
Please.
I don't know because I haven't seen it yet. So as to the motion to strike on statement 1, I'm going to take an advisement because ruling on it now.
The jury knows, like.
Because I just don't have that evidence in the case, okay?
Thank you very much, Your Honor.
All right. Since it's 12:30, you want to just take lunch? Go ahead and let the jurors go to lunch and come back at 1:30. Does that sound okay?
Elon Musk pays for her donation. Elon Musk buys Twitter. Is Elon Musk gonna remove tweets?
All right. Do you want to do it now? Okay.
Cue the X-Files theme song.
All right.
Interesting. I actually enjoyed the way he did it. Yeah, it was kind of lengthy, and I think he buttered too thick, right? But the fact that she was considering it, right? So why he went above and beyond. So I think what he did is that he took he like dismantled it in a bunch of parts, right? So every statement in the article, and then he attached a case law to it, and then an explanation of how they correlate, right? One after the other, and then in between, a bunch of garbage, but it is what it is. I mean, a little bit of theatrics here and there, a little bit of nerd voice equals win, voice acting, even some Zoomer jokes like everybody and their grandma, guys, I don't think it's funny. I don't think it should be in the courtroom, and I think this overall kind of doesn't go too well for them. But I mean, it's good memes. I don't know. Amber Heard's lawyer. What is this?
Nice argument, Senator. Why don't you back it up with a source?
My source is that I made it the fuck up.
Okay.